Friends, we are starting now. Today is 170th Friday group meeting, sir. The topic is Federalism, multiple facets. The speaker is our beloved senior advocate and MP, Rajya Sabha, Abhishek Manu Singhvi, one of the topmost lawyers of this country, is kind enough to give this spacious time to us. We are very grateful, sir, on behalf of Friday group. Sir, you are addressed as a 60th Friday group, institution pillars of Indian democracy. So that time it's a very, today is totally different. Today is luckily 170th. After 110 meetings, you are addressing us, sir. I request Subhav Dev will give us a few introduction. Okay, start.
Fred Rodel very famously said, "It is a lawyer who runs our civilization, our governments, our businesses, our private lives. Most legislators are lawyers. They make our laws. Most presidents, governors, commissioners, along with their advisors and brain trustees are lawyers. They interpret and enforce our laws. There is no separation of power where the lawyer are concerned. There is only concentration of all the government power in the lawyer." Good evening, everyone. Thank you for showing your presence. Although Dr. Singhvi doesn't need any introduction. However, just to quickly refresh what we all know already, Dr. Singhvi is a politician and a lawyer. As a politician, he is member of the International Congress and a current member of the Parliament of India, representing West Bengal in Rajya Sabha, the upper house of our parliament. He is also a spokesperson of the International Congress and, we all know, senior advocate of the Supreme Court of India. His father, Lakshmi Mal Singhvi, was a scholar, advocate and was also elected to Rajya Sabha. Now let me just introduce to the positions Dr. Singhvi held or is holding today. At the age of 37, he became the youngest Additional Solicitor General of India in 1997. And in 2001 onwards as a national spokesperson of Indian National Congress. In April 2006, he was elected to Rajya Sabha. In August 2006 until May 2009 and August 2009 to July 2011 as a member of the Committee on Personal Public Grievances, Department of Law and Justice. August 2006-2007, member of Joint Committee of Offices of Profit Members, Joint Committee to examine the constitutional and legal positions relating to the Office of Profit Member, Consultative Committee for the Ministry of Urban Development. September 2006 to 2010 as a member of Committee of Privileges and July 2010 onwards member Consultative Committee for the Ministry of External Affairs. July 2011 onwards chairman of Committee on Personal Public Grievances, Law and Justice. Now if I continue, will take an additional hour. So keeping various factors in the mind and the time we have today is very limited. Hence, I would like to hand over the mic to Dr. Singhvi. So welcome you today. Please carry on.
Friends, one more interesting information I will give it to you. L.M. Singhvi's photo is there, the portrait is there. His father. Sir contributed to this library to 25 lakhs. After that only it is an entire information.
Thank you, friends. As they say, everything requires a sutradhar, and G.Seshagiri Rao is the sutradhar who has carried you to the 170th meeting. It's no mean achievement. You need one driving force, one person who has the determination, the will to continue frequently against all odds. And I think I must start by commending him heartily, as I did when I delivered the 60th, several moons and pre-pandemic. But since time is short and this topic is like the ocean, let me start straight away and plunge into what I think are broadly 10 broad defining heads of the vital subject of federalism. And let me start that first of those heads on federalism with the contextual setting, the essence of which is diversity. And in a sense it links to where I left off last time I'm reminded by Rao that I spoke on institutional pillars of Indian democracy. Well, India has many institutional and non-institutional pillars of our democracy. The world's largest and a proud democracy. The only one, by the way, which has remained a vibrant democracy out of the 30, 40 odd countries which emerged from the yoke of imperialism between the 1930s and 60s. We are the only sole exception where amidst Africa, amidst South Asia, amidst East Asia, Middle East, large parts of South America, which remains an exception amongst the wrecks and ruins of constitutionalism. So where I left off last time were institutional pillars which I had discussed with you, like the CAG, the Supreme Court, the Election Commission, the Army, and even more important, the non-institutional pillars, which I had also discussed with you, secularism, socialism, and so on. In that setting fits a very singular and a very important non-institutional pillar of Indian democracy, and that is federalism. One must start looking at the contextual setting of federalism by the acceptance and realization that the most diverse spot on planet Earth is India. People, in America I go and people talk of salad bowl, of melting pot, and you go to other countries and you look at diversity. And I'll sometimes smile and laugh to myself. The diversity in India is incomparable to any other spot on planet Earth. You have the second most populous country, the seventh largest in area, now somewhere near the third largest in GDP, very large in purchasing power parity, where smells, sounds, rituals, dresses, religions, ethnicities, languages, diet, foods, races, you cannot have a more bewildering array of diversity than India. 22 scheduled languages, 700 mother tongues, 2000 dialects, the birthplace of 4 religions, Hinduism, Sikh, Jain and Parsis, well, not the birthplace of Parsis, but a very important center of Parsis, and second largest to many more, or third largest to many more, like Buddhism and Islam. So in this context, I think federalism is as much a self-preservatory non-institutional pillar as a vitally necessary pillar to preserve this diversity. Moving on to the somewhat more conceptual and abstract things before I come to a fascinating story about federalism. What are the concepts and the philosophical origins of this concept? As Alexander Pope said in his famous words, "For forms of government let fools contend, whatever is best governed is best." So it doesn't matter if you have federalism, you may not be successful. It doesn't matter if you have secularism, you may not be successful. And without that also you could be successful. So this is ultimately the success of those who operate it. But the word federal comes from the root fidus, the Latin word fidus, which is broadly a pact or a covenant. So federations or confederations signify compacts between sovereignties, between the central sovereignty, between several diverse state sovereignties. And then you have a whole series of different kinds of federal models. And I will not bore you with the technicalities of it. You have asymmetrical federalism, you have top-down federalism, you have bottom-up federalism, you have aggregative federalism. Now our Supreme Court, in Chief Justice Mishra's order in the NCT earlier Constitution bench, has added pragmatic federalism. The Honorable Prime Ministers past and present have added competitive federalism, cooperative federalism. Some of this is semantic, but the conceptual part is that there are very few true federal units in the world. One of the truest or the closest to a real genuine federal unit is USA, because that is what is known as a bottom-up federation. Bottom-up because you had pre-existing independent countries, nations, which surrendered partially sovereignties to come together and form the United States of America. So that was bottom up. Most other countries have a top-down model, as India does, where the federal polity is really a division of the central sovereignty into different states. Also, the concepts may vary. For example, in USA, these are more matters of interests, of competing interests. In India, it is more a matter of competing identities, because we have so many different diverse identities. For example, if you read the Federalist papers, in fact they are called Federalist papers, they are something broadly akin to our Constituent Assembly debates, if you make a loose analogy. You will find that giants like Madison or Hamilton, Alexander Hamilton, their main concern was that the identity and the power of individual states should not be submerged in the central new sovereignty they are creating, the United States. Their main concern was that howsoever small a state or howsoever large a state, it must continue to have co-equal power. Territorially small or population-wise small, they must continue to have co-equal power in the federation. Otherwise, the Texas will swallow up the smaller state, or other big states like California will obliterate the identity by their sheer numbers and size of smaller states like Maine and Connecticut. And also it was felt, because they had experienced British tyranny, the US coming out of it, it was felt that you must always keep the central government under check. There must be a countervailing force to the central government, which doesn't allow the tyranny of the central government, which they feared at that time would be like British tyranny, to overcome the decentralized sovereignties of the states. So that is the philosophical backdrop of the way the US Constitution was created, and barring a supremacy clause, which is never used as far as I know in US, which says that this is a supremacy clause in some kind of emergency the center can act. The US has very, very decentralizing bottom-up federalism. In India, the approach was exactly the opposite. We had experienced some terrible times during the so-called partition years, mayhem and destruction, communal riots, divisiveness. So the animating thought process was that we must not allow the encouragement of fissiparous tendencies, of breakaway tendencies. We have to hold this union strongly together, because we are a young union. And who knows, tomorrow there will be succession, there will be departure, there will be weakening. So there, and you'll find the Constituent Assembly debates replete with this, any number of discussions, that yes, we need to have federalism, we need to have decentralization, but we need to keep the center very strong, because we've had this terrible breakaways, breakups, and the Bangladeshis or the East Pakistans and the West Pakistans and all that. So the two were very different animating underlying philosophies. I now turn to the third aspect, the third head, of how in the initial years the Constituent Assembly viewed our federalism. And there's some very quaint and some very divergent views. Of course, words were different, but they can be reconciled as semantics. Somebody like McWhinney actually said it's essentially unitary, which is largely true. Granville Austin called it cooperative federalism. The truly correct phrase, according to me, was used by the Australian jurist, Kenneth Weir, who said that, look, they have broadly taken the English model, which is essentially unitary, but with some concessions to federalism. So he used a nice phrase which is stuck in our vocabulary. India is quasi-federal. It's neither unitary, nor, of course, certainly not truly federal. Quasi means akin to some degrees of federation. In the debates, different people accurately and not so accurately described India. In the debates, Kamath said it's a centralized federation with a facade for parliamentary democracy, quote unquote. Of course, a centralized federation, according to me, is an oxymoron. It's a contradictory phrase. You can't have a centralized federation. Damodar Swarup said it is actually a unitary constitution in the name of a federation. Hanumantayya said, these are all quotations, it's a federal constitution which in essence is almost a unitary constitution. And that is not the intention of those who have decided to make this constitution. That is what he said. Ironically and interestingly, Keshwananda Bharati got it wrong when there's a nice delightful phrase in that long judgment at page 553 for those of you who are interested. They said, our constitution is federal in character, not unitary. That, according to me, is the single biggest blunder in Keshwananda Bharati in terms of accuracy. But there is this nice sentence there. Probably more accurate is the 7-judge judgment of the state of Rajasthan in 1977, which used a nice phrase, relatively more accurate. It said, the Indian constitution is amphibious or amphibian. It can move in a federal or a unitary plane. So it changes. It's a bit like a chameleon, which changes. The interesting part, as I show you, is, of course, if you take the structure of our constitution, it is clearly heavily inclined towards unitary. And I have got innumerable examples, but I will only give a few because this can be multiplied, it will take time. But the residuary legatee of all powers falling to the central government under entry 97, read with Article 248, means anything not covered goes to the central government. These are all indicative of unitary models. Under Article 249, Parliament can make a law even in national interest, even though it's in list 2. Quote unquote national interest. That's a very subjective phrase. Under 246A, capital A, which was added by the 101st Amendment in 2016, that allowed you to make GST. As you know, states used to have octroi, entry tax, so many different taxes. In the old days when we started practice, you had those state taxes. They gave up those sovereignties, but they could not come under GST because there is no power to make GST under list 1, list 2, etc., list 3, etc. So they had 246A, which allowed you to write roughshod over all entries. That's again centralizing tendency. Of course, you can make laws in the public interest and national interest with articles like 250. Parliament can override list 2 to implement a treaty under Article 253. And so on and so forth. Of course, the most outstanding example is when you declare an emergency. The emergency makes Parliament the enactor over all the 3 lists. So the structure, and of course somebody said that the All India Service concept itself cuts across, the All India Civil Service concept, cuts across a true federal principle, because you cannot really have an All India Service in a true federation. Many of these provisions are not found in comparable federal countries like Switzerland, Australia or Canada. Leave aside USA. USA is a very heavily federal country, but the other countries like Canada, Australia, which are more on the UK model, they do not have such a strong centrifugal force in favor of unitary centralized governance. The interesting part is, and there are many more provisions, I am skipping that to save time. The interesting part is that in possibly the longest constitution of the world, not the longest, but amongst the 5 or the 7 most longest constitutions in the world, Indian Constitution, it's fascinating that the word federal or federalism is not used. Not in the preamble, not in Article 1, not in Article XYZ, nowhere. I once did a Google search of the soft copy of the Constitution and I found almost 8 or 9 articles where the word federal is used. But when I went into the articles, they're all about the federal code. Each one of them. You know, articles 112, 128, 135, 366. Federal code, as you know, was the precursor. Nothing about federalism. Nothing about federal decentralization. So the fascinating part of this part of the story is that something which is not found as a specific written pillar in the preamble and nowhere in our 400 odd clauses, articles, constitution, or the longest in the world, that is still held to be the basic structure of the constitution. Federalism has been held to be a basic structure of the constitution from Keshwananda. It is of course most nicely and artfully and dexterously packaged in Bombay. But it has been a part of the basic structure from Keshwar and the Bharati times, without finding a mention anywhere in the constitution. So you have this bit of an anomaly, and you have clearly a constitutional document, the largest or amongst the largest in the world, with a clear unitary bias as far as the texture, the design and the text is concerned. And I've given you 7-8 articles, I can give you 20 more. If you examine the constitution, if push comes to shove, everything can be centralized. Before I come to the fascinating story of how a heavily central biased constitution has in operational reality become more and more federal. That's the heart of my story. Let me spend a few minutes on some aspects of the approach to of the CAD, of the Constituent Assembly, and of the conceptual differences in our articles from other federal countries. Some other countries have the concurrent list. Australia does, for example. But you will find that slowly over time, and even from inception, the items or the numbers in the concurrent list in India have been ever increasing. I believe at last count there were 49 or 50, or even a little more. In other countries they've been diminishing. Australia has less than 35 now. List 1, India has 99 articles, entries, and Australia has only 31. Amendments to the Constitution, except in 4 or 5 cases, actually don't require the states to be considered, to be consulted. Under 368 you can amend the Constitution left, right and centre. States don't come on board, save and except in 5 areas. One is the election of the President of India. If you have to change the Electoral College, you have to get states on board, with half of all states ratifying the constitutional amendment. The second category is if you make changes in high courts or the union judiciary, or you make changes in the lists of the 7th schedule, or you make a change in the number of people a state can send to Parliament. And of course there is a 5th category that if you make a change to 368 itself, which allows you to amend, then also you have to consult states. But barring these 5, a vast majority of amendments can take place only by 2/3 present and voting, and provided it's above the majority of the House. Also you will notice that truly federal countries like USA have 2 sets of laws operating on each citizen. You and I have only 1 set of courts operating upon us. There is a single line of courts. They may be spread over states, but the line of courts is single. On 1 citizen, only 1 set of courts operates. In America, 2 sets of courts operate on every citizen: the federal court and the state court. That's another very fascinating aspect of federalism. Let me now come to the fascinating story of how, from conception to operational reality, there has been this divergence in 1947 and 50, something heavily centralized, to what we have now reached, the journey for the last 75 years, as we are anyway now in Amrit Kal. Now, from conception to operational reality. Before I give you my 5 or 6 examples of that fascinating journey, I want to say at the outset that federalism in India in operational reality, not in theory, not in the constitution, is linked directly to the way India is structured, the way we have to manage diverse identities. People believe that federalism is vital for managing diversities in India. If you didn't have a federal approach, if you did not have an approach of inalienable component of shared sovereignty or participatory sovereignty, we the people are actually two sovereignties. We the people is not just the central government sovereignty, but is also the state sovereignty. Unless you recognize that, you cannot manage the diversity of India, is the philosophical view about Indian federalism. As somebody put it rightly, it said it's the safety valve to manage 3 Ds. The 3 Ds being dissent, discomfort and dissatisfaction. It is vital to manage and to channel anger and dissent into manageable outlets, like a safety valve on a pressure cooker. Somebody else has said that it quarantines conflicts at local levels. If you had everything centralized, like a pressure cooker, it would burst at the top. Decentralization, which is another form of federalism, confines disputes and, as they say, dissent, discomfort and dissatisfaction. It quarantines them at state level or even at sub-state units. And therefore, we now turn to what has been rightly called unintended federalism or inadvertent federalism or accidental federalism. Why? Because what was in conception of our designers and makers a unitary design has by accident, inadvertence or by a process of evolution, something like an autopilot, become much more federal. Now I have 6 such examples, and there can be many more. And obviously I don't have time to go deep into each, but I'll touch upon them. Something like a fan dancer, touch upon the subject without really covering it. Linguistic federalism is the first of those 6 federating influences, which has carried India from 1950 to what we are now, a very different India. Many of us in this room, the younger lot, may not be aware of the language riots of the 50s and 60s. Certainly some of my colleagues here, my friends, are aware of it. Accommodation of linguistic diversity is itself a very vital part of federalism, an important component of which is linguistic federalism. The creation of our states, not only in 1956 but other times, along linguistic lines, accommodated that diversity, gave it an area to escape dissatisfaction and dissent and discomfort. Most of our states at that time, from Gujarat to Maharashtra to Karnataka to Tamil Nadu to Kerala and so many more, were created on the basis of that linguistic approach. On the whole, I believe that the so-called 3-language formula, this was my personal view, it's a very contentious issue. On the whole, the 3-language formula has worked well. It has acted like a safety valve. It has accommodated the diversity of a centralizing language, a foreign language which is very, very minuscule, but without which you can't progress and prosper in the world, and the local language or the regional language. As a matter of fact, when I started this TV business in 2000, I said in 2005 that the biggest promotion of Hindi is not by imposition. Every time I try to impose Hindi here, there's a reaction. There's bound to be a reaction. There should be a reaction because imposition is not on. And as a parliamentarian now for 16 years, we get a lot of things in English and Hindi. We have a Hindi Divas and we have to promote in so many different ways Hindi. It's all good. It pushes a certain cause. But possibly the biggest promotion of Hindi across, and today a lot of the South Indian friends speak very good Hindi, even better than North Indians. The promotion of Hindi has happened by non-imposition. And I have said more than 10 years ago, that 15 years ago, that probably the single most important reason is a little noticed reason. The proliferation of media, of visual media, where regional languages and Hindi language channels have proliferated, and they call people, when I used to, those old days in 2000, 2001, 20 years ago, used to go to a studio for your 2 minutes of glory, you had to drive 2 hours to Noida. Nowadays, of course, we have OB-vans. But, you would have a leading South Indian politician, you would have me, you'd have a leading North Indian politician, you would go, and they would just speak in the Hindi channel as they, without being conscious. Tutti-futti Hindi ho, Puri Hindi ho, Adi Hindi ho, they would speak. That has led actually, and the fact that this is now pan-India has led to. But ultimately the 3-language formula and the fact that we are conscious of diversity and that linguistic federalism and not jingoism and imposition has been one of the first aspects of a of a diluting effect on what was the position in 47 and 50. Second, independent courts. But not independent courts. Our courts have been independent for a long time, largely so, not always. But vigorous, prompt and decisive. Three crucial words. Way 356. I've had the privilege of appearing in the last 20 years in almost all the important defection, government formation and 356 cases in different avatars. And I once noticed this, of course, many years ago, and now, of course, I've used it in many lectures, that after 2000, the invocation and use of 356 is fractional compared to pre-2000. It is not because the heart of governments has become pure after 2000 and every government before 2000 was malevolent. It is because court intervention has become swift, prompt and decisive. Poor Ramakrishna Hegde, when he filed Pommai, he was the man who was unseated. He won the case, but few people remember that he won it after 3 governments had changed. His own government went, 2 other successive governments went. The judgment came after years. But Rameshwar in Bihar's case in the early 2000s, or so many others, happened within months. So the important point was that what is 356? 356 is the biggest anti-federal article in the Constitution, because it allows me to take over your government. So it's anti-federal. It centralizes and takes over a state government. But the use of it either has diminished, more importantly, when misused, it is rectified. And I have had the privilege of appearing in Jharkhand, Uttarakhand, Karnataka Midnight and Karnataka Normal, 2 matters, Goa, Maharashtra, Arunachal. In all these cases, there was either an attempt to do egregious misuse of 356 or an attempt to change governments by various forms, including horse trading. This way or that way, I am not on politics, I am not on the merits of the case. The courts intervened, the courts decided, and the courts rectified. So what used to happen in these cases of an anti-federal article, that you would get the fruits of your benefit. So this man would be unseated, and after he had completed his own tenure, after the usurper had completed his tenure, it would be declared that his unseating was bad. That having gone, therefore today you have 356, one of the most single major anti-federal clauses in the Constitution, being reduced to a very puny size. That is what I call, if I may use the phrase, judicial federalism, or you can use any other phrase. Third, as we are talking of the journey from conceptual unitary to inadvertent federalism in practice. The third was the Panchayati Raj amendment, the as you call it, the 73rd and 74th constitutional amendments. I happened to be witness as a young man standing next to my father when Rajiv Gandhi called him. And he said, Dr. Saab, you talk about and give lectures about Panchayati Raj, but everywhere around you Panchayati Raj is in tatters. It is in ruins. You should do something about it. I am proposing that I appoint you as chairman of a high-powered committee to propose a constitutional amendment to revive Panchayati Raj. This was in the 85-86. The so-called L.M. Singhvi report on revitalization of Panchayati Raj came in the late 80s. In 92-93, these 2 constitutional amendments came based on that report. Of course, they added municipalities also, because that's also decentralized. But what are we talking about today? We are talking about pro-federal operational reality. Do you know how much more federal you have become since Panchayati Raj has been institutionalized? Or since you have provisions about municipalities? As a member of parliament, first in Rajasthan and nowadays in West Bengal, if I use my MPLAD funds, the member of parliament funds, to suggest a program or a project which we are entitled to do as of right, and the government has to implement it, more than 70% time sitting across my table would be a lady who will be the head sarpanch or the member of the thing. There are now 15 lakh ladies who are empowered in positions of power to decide how to run panchayats. There are now, of course, there's a lot of, I'm not saying everything is hunky-dory, a lot of problems. But decentralization at the panchayat level, at all three levels, state level, mandal level and bottom level, has happened in a big way. As one of my colleagues put it rightly, it has changed from 3 F's to 3 E's. Previously the approach was functions, finances and functionaries, the 3 F's. The approach, because of decentralization at Panchayati Raj level, lacks of women, reservations for women, and being able to decide your own bridge, your own lawn or garden in your own village for expenditure and administrative purposes, has turned the 3 F's, functions, finances and functionaries, into the 3 E's, empowerment, entitlement and enrichment of rural power and local power. Many of us forget that there are 3 lists in the 7th schedule, we all know that. But there are similar lists in the 11th schedule and the 12th schedule. The 11th schedule has 29 subjects which the states are encouraged to devolve to the panchayati level. So just like the 3 lists give parliament some powers and state some power, schedule 11 and 12 encourage states to give power to panchayats. Of course, it's a different matter that states love to clamor for power from the center. But when it comes to parting with their powers and giving or empowering or operationalizing those lists, they are very hesitant. Most panchayats have not got the operationalized power, but the lists are there. And Panchayati Raj is growing in a big way. Municipalities. You notice a provision like 243 U for under. It says in 5 years you shall have elections to the municipalities. If your term ends in 5 years, you have to have the election. Previously there were municipalities taken over, superseded by an administrator, ground of delimitation, ground of 100,000 excuses. You wouldn't have election for 10 years, 15 years. So there's no decentralized governance. By this constitutional amendment 73rd and 74th, you have mandatorily said that the word used is no longer. The Constitution says 5 years and no longer, quote unquote. And very interestingly, there have been 3 judgments, 2 recent. The Constitution bench in Kishan Singh Tomar, much earlier, said that this no longer means mandatory, you have to have. I mean, barring the fact that the whole town has fallen down and there's an earthquake, you can't extend. Then they tried 2 usual, it happens in India, stunts as I call it, that we have to do delimitation. So we will have the election after, beyond the 5-year limit, because we have to do delimitation first. The Supreme Court recently in 2022, judgment of Rahul Ramesh Wagh, categorically held that delimitation cannot be a basis for delaying a 5-year election limit. If you want to have the election, then do delimitation afterwards. Another judgment, that was a judgment from Maharashtra. And the second judgment, also 2022, is from Madhya Pradesh, where the same thing was reiterated by the Supreme Court. Of course, mind you, Supreme Court, the problem in our system is ex post facto. You commit a wrong, and then I come and correct it by the Supreme Court. The Supreme Court does not prevent the same wrong being committed again, contrary to the existing law. So we had in Delhi some time ago, last year, where after 5 years, delimitation was used to extend the 5 years to 5.5 years. But luckily after 5.5 years they had the elections. So the point is that there is a movement towards decentralization, which is the third major aspect. The fourth is economic liberalization. Centralization versus decentralization also means license Raj versus liberalization. Whether you call it 1985 or you call it 1991, there is no doubt that first generation reforms and second generation reforms have made the centralizing power of the government much less. Many of us don't notice it, but you ask your business friends. A central cabinet minister and a state chief minister have the same rank and the same power. But actual power of a central cabinet minister is not even 1/4, according to me, compared to a state chief minister. Because after 1991, slowly, the power or the necessity for me to come and give pranams at the center, most of the power is gone. It's decentralized. License Raj is less. So actually, this has made it a much less centralized, Delhi-centric country. Of course, it is not the same in states to the same degree. The state chief minister in actual de facto power has probably 3 times more power than the central cabinet minister, because there the decentralization below the state at the panchayat level or the municipality level is more limited. But most of the red tape, the license Raj, every businessman friend of yours of the old days would fly to Delhi every week. You'd have an office and a guest house here. You'd have a liaison man here. That has all changed. I know some leading industrialists who say that we don't need to come to Delhi at all for years because the power is not there. No license is required. The fifth decentralizing pro-federal aspect is fiscal federalism. Ultimately, what matters is where the shoe pinches, where the money comes from. As you know, while the vast majority of collections and taxes are at the central level by central levies, and in a sense now more so with GST, the sharing of those levies is what the states survive on. And without fiscal federalism and decentralization, I can give all the sermons I like, but I will be the boss because I hold the purse strings. Just like your wife is the boss, she holds the purse strings at home. You cannot unless you decentralize that power. And that is based on the simple arithmetic that for decades in India, the devolution of funds from center to state, there are 2 or 3 categories. One is grants, one is tax sharing, one is other forms of devolution. All these 3 put together for decades did not exceed 30 to 33% of the total 100%. So if 100% was in the 100 rupees was in the central pool, 30 to 33 rupees would go to the states. That figure now is just under 45%. In fact, the last Finance Commission has said it should not go below 45%. So states, of course, there is much to be done. There are deceptions and juggleries and manipulations going on. It happens everywhere. But there are delays in the center giving. But in principle, between 43 to 45% of the 100% kitty goes down to the state. This is a great increase in fiscal federalism, which is the monetary part, which is the most important. The sixth, and possibly a very, very important aspect, is the aspect of federalism, which is coalition governance or regional parties. A lot of us, including myself and many of you, love in their Delhi drawing rooms to think of India as one, one and one. Everything should be centralized, uniform. Uniform not in the sense uniform interest, thinking, habit, control, everything. So political parties must be only 2, 3, 4 or 6. But the great revolution in India is, and a lot of us hate it because we don't like the chaos, the cacophony, the chick as we call it, of multiple parties. We love a strong single party and a strong countervailing party and maybe 2 other strong parties. In reality, the biggest great achievement of federal India has been regional parties. Today, larger tracts of India are governed by regional parties than by either the governing ruling party today or the erstwhile governing ruling party, the Congress. That is the essence, and even where, take the Northeast. Northeast, the current ruling party is the government in power in at least 3 or 4 states. But actually it is a coalition there also of the regional party. It's his regional party which I have actually taken over and managed to become a new party. So therefore, you are actually promoting local aspirations, regional aspirations. Big states like Tamil Nadu, West Bengal, Odisha, there are so many examples. You can give all kinds of semantic names, competitive federalism, cooperative federalism, but the reality is that the old paradigm pre-91 or pre-89 of a dual party rule or a long single party rule has changed, and political colors are triple, quadruple or quintuplet. Political colors are not binary. That's a reality we have to get adjusted to. It requires a lot of adjustment, I'll show you when I come to that part. It requires a lot of wisdom and maturity, because if you are used to single party or dual party or triple party rule, you don't have to make so many adjustments. But today, in matters of giving aid, do you have step-motherly treatment between him and him? They are both your two states, but just because the political color of this state is different, and the political color of this state is different, and the political color of this state matches my political color at the center. This can't be written in a constitution. This is the essence of the federal spirit, that it is how you operate it. As Alexander Pope, I quoted to you, for forms of governance, let's fools contend, whatever is best governed is best. Earthquakes, cyclones, floods. Take for example, and we are doing this in courts every day, I am appearing in those matters. Take for example the jurisdiction or the lack of jurisdiction of the CBI into a state which has not given its consent. It doesn't matter why, you are the elected person, if I don't want CBI, I don't give no general consent, in an individual case I can give or not give, but you can't come into my home without my consent. Now you need to respect that federal spirit, not say simply that look, what the hell, there is a bad crime here, why can't the CBI come? This is the essence when the political color changes, which has not been true of the first 60 years of Indian independence. The sixth aspect of this very significant decentralizing, federating influence is GST, which of course is a great victory for federalism in conception, but possibly an equally great betrayal in operation. So it's a very interesting combination of a victory and a betrayal. Victory because 246A and related Article 279A were enacted by amending the constitution, because without that you could not have GST. Secondly, there was a great reverse sacrifice by the states, who said that I will give up my state tax, he will give up his octroi, he will give up his entry tax, he will give up some other sales tax, state sales tax, so many taxes are there. And we'll put them all into one hodgepodge of the grand GST scheme. We'll have excise, central state tax, state sales tax, everything. That was a great achievement, and I think it showed a maturity in those who proposed it and those who implemented. And I'm not getting into the politics of it as to when you criticized whom and when what happened. But when you give up your local state taxes, the entire debate, and it's very interesting if you read some of that, was a conception of 14% per year increase of growth in the GST. So it was said, look, you are giving up octroi, you are giving up state sales tax, and different states have different figures. So you are losing 100 rupees, you are losing 1000 rupees, you are losing 2000 rupees. We'll make up by giving you, because GST will grow at 14%. So there was what was known as deficit compensatory payment by the central government to the states. Otherwise the states would not have perhaps even agreed to GST. You required, under this 246A required, the Article 368 amendment to the Constitution provision requiring assent by more than 50% of the states. Actually, unfortunately, at last count, the debate is still going on. On this compensatory reverse flow, 2.35 lakh crores minus 97,000 which has been allowed, that is roughly 1.35 lakh crores, is outstanding to be paid by the central government as compensatory reverse tax make-up funds, if I may call them. Now, there are, you see the fights every day, you have somebody from Bengal shouting and you have somebody from Kerala shouting and you have all this going on. The point of the matter is, when you operate federalism, and this is by the way recorded in parliamentary standing committees, it is recorded by RBI, and it is recorded in any number of debates, and in the GST Council also, in the GST Council, that this amount has to be paid to the states. But actual payment has either not happened at all or has happened infinitesimally or fractionally. So therefore, as I end up this sixth facet of accidental or inadvertent federalism, namely the GST, I think these aspects of static division of tax pool at 43%, it should be minimum 45%, decrease in the repatriation of compensatory funds, and so many other issues related are to be kept in mind. My 7th of my 10 heads, I'll try and wind up by 5:30. I've done 6 heads. My 7th of my 10 heads is the role of the governor. This can be a lecture by itself. But governor and federalism are like intertwined cousins. And unfortunately today and in the contemporaneous recent times, possibly the biggest inroad to federalism is being done by the office use or abuse or misuse of the office of governor. It's fascinating how much of this was anticipated by our framers. Our framers were amazingly wise. They took the wrong decision, but not without anticipating the right one. So everything is discussed. If you actually ever have time, you just keep on flipping the pages of the CAD, you just find an amazing vision. Now, the principal participants on the governor issue were Kunzru, T.T. Krishnamachari, P.K. Sen, Durgabai Deshmukh, Shibbanlal Saxena, of course, spoke on everything, and Sayyid Saidullah, etc., of course, apart from Nehru and Ambedkar, who always were the main people who spoke. The issues which troubled them were, one, that should the governor be elected or nominated? There's a huge debate in the assembly debates, he should be elected. Why not? Versus nomination. Second, should he hold office during the pleasure of the president or the state legislature? Third, how do we manage this dual authority? The debates have this nice phrase, एक म्यान में दो तलवार. प्रदेश के स्तर पे एक म्यान में दो तलवार कैसे रह सकती है? एक मुख्यमंत्री, एक राज्यपाल. One sword, two swords in one scabbard. And a fourth debate was, why at all have a governor? You don't need a governor. A governor is ornamental in many ways. You can have an administration without a governor. And ultimately in all these four, there are lots of debates which I don't have time to go into. Ambedkar ultimately prevailed. K.M. Munshi prevailed. And they said, we are adopting the British model. We can't have an elected governor, mainly on my ground of ek myan mein do talwar. You can't have two elected people, a chief minister and a governor fighting. By the way, that's precisely what is happening. An unelected governor and an elected chief minister are fighting in many states. But the object was this: minimize discretionary power. Don't have an elected politician, because ironically the debates felt that the unelected chap will be more sober. And there are debates which say he should be a Nobel laureate, he should be a wise academic, he should be a learned person. These are of course all sermons, easier said than finding a person like that. Then they said that better to have a nomination by the centre, because he'll be just a representative, just the eyes, ears of the centre, and have no, state legislation should not come into selecting him. Many people of course batted strongly for elected governors. Krishnamachari said he should not be an agent of the centre. There should be no diarchy. The main word coming in these debates is diarchy, dual division of control. And then Ambedkar settled the debate by saying, look, this is a largely ornamental post. In fact, he has a very nice passage. He says, I find it difficult to believe that many people will agree to be governors. He said, according to me, I am worried that most people will not agree to be governors. It's an ornamental post. And he says, you just settle for a unelected, nominated, and very limited powers. On 31st of May 49, he said, Ambedkar, quote, we felt that the powers of the governor were so limited, so nominal, and his position so ornamental, that probably very few would come forward to stand for election. Then again he said on the same day, that is the 31st of May 1949, if a governor is a purely constitutional governor with no more powers than what we contemplate expressly given to him, and has no power to interfere with the internal administration of a provincial ministry, I personally do not see any very fundamental objection to this principle of nomination and not election. Then he again said a month later on 22nd of June 49, the first thing I'd like the House to bear in mind is this: the governor under the Constitution has no functions which he can discharge by himself. No functions at all. And then of course there is a Sarkaria committee report after that, which has paras after paras, and I've got the paras here, I'm not going to read them, about the limited powers of the governor. He is to be the friend, philosopher and guide of the state administration. He is to support and endorse. Today, I don't know what's happening. I'm appearing in those cases, I'm advising. I mean, things like we could never believe that things like the address to the assembly, tweets, press conferences, daily fights, letterbazi, press conference bazi, statement bazi, and it's not one state. You can count at least 5 states currently which are experiencing, from Kerala to Maharashtra, from Bengal to Tamil Nadu, everywhere it's going on. And then of course the constitutional powers themselves make it clear. His powers are, 163 says CM must head the council. 174 says his powers are to summon, prorogue and dissolve. 175 says he must address. 10th schedule says nothing to do with the governor, only speaker. 200 says assent to bills. If you want case law, from Nabam Rebia to the well-known case of Shamsher Singh, which is 7 judges. At that time in 1974, Nabam Rebia's 2016 constitutional bench. They repeat, his powers are extremely limited. He has no role in all this defection business, etc. Unfortunately, you come back to what Ambedkar and everybody else said. You cannot make the best text, you cannot make the best constitution. You can only hope and trust that the men and the women who operate it do it fairly. As I leave this topic of governor, I must underline a huge error, according to me, by a judgment of the Supreme Court, which is now over but might be misused in the future. Please discount it, because I was the losing party. So please discount whatever I'm saying. But I believe it's a wrong judgment. That's the Madhya Pradesh judgment of 2019, where the court, the division bench, has held that the governor can order a floor test at any time, not only at the inception when the government is elected, but during a running government. I find it difficult to, I've searched, I of course argued the case from the losing side, but there is no provision in the constitution which gives a role to the governor to decide these are all matters of the assembly or the speaker. How you will have a floor test, when you will have a floor test, how much you will have, 1 day, 2 day format, these are all matters which the speaker, there is nothing in the constitution. And this is of course in an oversimplistic nutshell, but there are other parts of the judgment where there is a political color at the center which is different from a state. This provision can wreak havoc. The government can decide that today, because of some instability created temporarily, you must have a floor test. And you will actually, and it's not a question of right or wrong, governor becomes an agent of destabilization. And the constitutional scheme is disturbed. The effect of that judgment, the name is Shivraj Singh Chauhan versus Madhya Pradesh, 2019, is that after 22 members of the assembly had resigned without formally passing an order of acceptance of their resignation, the disqualification petitions of that pending for years, without waiting for the decision, the governor, not the speaker, directed a floor test, where the same 22 voted. And the result of that was, of course, this way or that way, a different thing. My 8th point is about 356 jurisprudence, which by the way is not 356 jurisprudence. It is linked to this whole thing about floor tests, about change of governments, about disqualification. The only takeaway is that in judgments like Karnataka, in judgments like Uttarakhand, most importantly, Uttarakhand deserves to be seen and read. It was ultimately affirmed in the Supreme Court. How judicial review, which is prompt, decisive, focused and nitty-gritty, it has changed the thinking of people saying, we'll do it once, we'll get away with it, and we'll see later there'll be a declaratory judgment saying, Mr. So-and-so was wrong. But by then, Mr. So-and-so has enjoyed the full fruits of his error. So these are matters where the Supreme Court largely in the post-2000 period. I don't think there are more than 10 or 15 or 20 examples, 15 possibly, of real examples of 356 use. Prior to 2000, there are 199 examples of use of 356. Partly because court intervention was slow, tardy and technical. My ninth, and I'm just coming to an end shortly, my ninth head relevant to federalism is the new paradigms, the new facets of federalism which are arising, which none of us had anticipated. People don't realize that the biggest contributor to the jurisprudence of federalism is possibly COVID. It has not been tested because in times of grave emergency, the courts will give only one judgment. But it's a fascinating discussion on federalism, which maybe will be tested, it should be tested ex post facto. The Disaster Management Act, which interestingly nobody has challenged in a real meaningful manner, and possibly, we all agree that we have to do drastic things to manage pandemics. So the result would probably be a foregone conclusion. But legally speaking, the Disaster Management Act has remarkable provisions which completely decimate federalism. I don't have time to go into it because Disaster Management Act can be discussed by itself. It is extremely wide and it is almost equal to Article 352 Emergency Proclamation. In particular, Section 10 and 10(2)(I) and other parts of 10 basically say that any direction during a pandemic by the central government must be obeyed. Any means any. If it is believed by the central government, and that belief is not really judicially reviewable effectively, that a broader balcony promotes COVID and a lesser balcony does not promote COVID, then they can give a direction in all across municipal laws, etc. doesn't matter, that you immediately cut half the balcony, or you pay less wages, or you pay, everything is closed but you pay the full wages. There are of course very important sections 30, 35, 51 and 62, which are blanket, non-obstant, and make the direction of the central government binding mandatorily on every authority, state, central, district, panchayat or municipality. Because I have no time, so I am cutting it short, but that's the simplest way of putting it. Mind you, when that direction is given, it doesn't bother about list 1, list 2, list 3. For example, wages. There are many articles which are entries are in the state list. But obviously on the ground of the pandemic, Disaster Management Act has very wide. Incidentally, other common law jurisdictions like Hong Kong, etc. have tested it and they've been a little stricter. They haven't allowed the pandemic argument to allow very, very intrusive statutory legislation. But, as I said, in theory, in conception, design and language, this is a suspect legislation. But even then, probably I would support it, as would most people in this room, because we've come through a very bad pandemic through it. It shows the mismatch between law and reality. As I end, let me say that the last broad head is the threats, the challenges and the future ahead for federalism. The threats and the challenges are very varied and many. They are from the small to the medium to the big, but it's the small thing which establishes the larger principles. Take for example a case where because of political reasons you force the CBI into a state which says I have not given consent. That may be a very small case because this particular gentleman is my favorite. I am the central government and I want at his behest CBI to go into this state, as the CBI. It may be very small, inconsequential, but the principle established is very large. You have completely violated federal principle. Because there is nothing clearer than entry 1 to section 4, 5, 6 of the CBI Act, the Special Police Act. The threat of even-handedness between governments of different political colors, not only in the center and some states, but between states, stepmotherly treatment, even-handedness. Vendetta politics. These are not written, you can't write these things in the constitution, but how you operate them. I believe that India is a proud democracy because unlike Bangladesh, where the two ladies cannot sit in Central Hall, the two warring ladies of Bangladesh, all our political parties, till recently at least, used to sit and do any kind of gossip there, irrespective of political color. The strength of our democracy is that what we can do in Central Hall, Nawaz Sharif and Ziaul Haq and this fellow, the cricketer, Imran Khan, can't do in the Central Hall of Pakistan. And that is because vendetta politics has been generally limited in India. It's not been absent. It started with one state in the south, it travelled to the east, and it stopped at the Battle of the Sardars in the north. But barring these 3 or 4 examples, and especially at the central government level, India has been very fortunate in not having adversarial to the degree of vendetta politics. That is the antithesis of federalism. That is something which will slowly emasculate this remarkable democracy which we have created. It therefore requires an extraordinary maturity, perspicacity, far-sightedness, which unfortunately frequently is conspicuous by its absence. You need to keep federalism as a guiding pole star, what the Chief Justice called the North Star recently. Whenever you interpret statutes, whenever you interpret constitutional provisions, so you are a judge, you are interpreting a constitutional provisions to have A or B, broadly similar outcomes, and you are undecided. Well, what should tilt the balance towards A is that it's pro-federalist solution. What should tilt the balance against B is that it's anti-federal. A very good example is what you see in and this of course I think it will be a very important judgment whether we lose or we win, the NCT Constitution bench, which is designed. That's going to come next month or the month after. But it doesn't matter which way it goes, it will be a seminal judgment. But remember, you can't please everyone. I remember Margaret Thatcher when I was a student in England many decades ago. She was a Prime Minister. She used to say, a person who stands in the middle of the road has the danger of being struck down by traffic on both the left and the right. Both sides traffic will strike you down. Judges sometimes, in trying to please everyone, achieve the worst result. Take for example the NCT case. Do you know that the NCT case started in Delhi High Court? It led to verdict X. It came to the Supreme Court, to a 3-judge bench. While they were hearing, they said we will refer it to a Constitution bench. Constitution bench in 2018 gave a 500 and 700 page judgment. Sent it back to a division bench. Can you imagine that 700 pages of Constitution bench led to a divided division bench? Justice Sikri and Bhushan. That's because you are designed to settle the law, be clear. Sometimes you have to bite the bullet and be black or white. You can't please this end and that end also. Like Margaret Thatcher, you'll be struck down by traffic from both the right and the left. So, after a constitution bench of 500 or 600 pages, you had a division bench, where the case went back, as you know, the case goes back, which divided. And then this all happened in 2018 and 19. And then in 2021, every day you open a newspaper, 2022, you are fighting them at each other's throats. Please discount the fact that I am a counsel for one of them. That is not the point. But you are catching his throat every day. Why? Because there is no clarity in the law. We have now argued a constitution bench for 5-7 days. I hope it doesn't repeat itself again. Win or lose, you have to create clarity in the law, how you interpret 239AA. That is important, and that is the job which only the Supreme Court can do. Because each day wasted in this futile jhagada of whether I can appoint him or transfer him, and whether he can come my secretary or he can be posted here or there, is a ridiculous thing. It just affects governance, and that too in the capital city of Delhi. Well, friends, I have come to the end. There are some unique features of federalism which I am not going to talk about because I don't have time, including in the Jammu and Kashmir context, where people believe that an unconstitutional third tier of federalism has been created. You have the central, you have the states, and you have the panchayat / municipalities. in Jammu and Kashmir, we are not talking of 370, we are talking of the abolition of statehood. Post-abolition of statehood, they have had a very interesting animal created which has no sanctity in the constitution at all. Nobody ever created this animal. It's a administrative created animal. The DDC, the District Development Council. The District Development Council is a kind of a mini assembly without there being an assembly. It's not a panchayat, it's a direct election where incidentally all areas irrespective of population have equal representation, 14 or 13 people. And they decide everything because there is no assembly, as you know, there at the moment. So the DDC, to which elections were held last year, decides everything. Now the DDC has no sanctity in either the center, it's not the center, it's not the state, it's not the panchayat. So it's by executive fiat, a whole new federal structure, whether created to be an agent of the central government, anti-federal, or created to diminish federalism, anti-federal, we don't know, again not tested in the courts. But that's a story for a later date. Let me end, friends, by saying first and foremost, thank you very much for being here and for waiting despite the delay. As I said, Parkinson's law says that the day, you have many Fridays when you get over by 3:30, 4 to 4, but on the Friday when you give a lecture, the judge calls out a case at 3:50. So, my apologies. But federalism is what federalism does. Federalism depends on the spirit in which you operate it. It depends on the institutional mechanisms, on the institutional structures. It depends above all on the men and the women who run it. It is only as good as the person who runs it. But irrespective, it's a treasure which we must cherish, which we must respect. We must enlarge and we must expand. And if we do not do these things, future generations will blame us. As they said in their famous poem, Lamon ne khata ki, sadiyon ne saza pai. Thank you very much.
Thank you very much, sir. Very nicely. Entire federalism you explained, from women reservations to Panchayat Raj to municipality to Kashmir and 356 whatnot GST, and ultimately federal structure is going to center. Before giving a vote of thanks by Shekhar Preacher, I will say special thanks to Karpagam, Justice Karpagam.
Very kind of you, all of you, waiting so late.
50 years just he completed. And, yeah. And, Justice Basant sir is here. Justice Nagamuthu sir, he is here. So all, they left, just left. Thank you very much. I request Shekhar Preacher will give vote of thanks. They just come to close it.
Thanks, Dr. Singhvi. We are in fact very delighted today. It's a much more expected mile even ahead to the good arguments and the opinion which you have expressed. So not only delay condone is rewarded, rather we are waiting for more delays. So 2-3 things, it's a mind-boggling. When we started as a student, we were told that our constitution is by heart is a federal, but in the working it's a unitary. But there are so many examples, central services, then finance commissioner, then 356, 352. Now you have created a dent in that situation by saying that it was a pro-unitary, but in working it become federal. So this is basically it's a new theory which we have changed after even 25 years of my practice, because perhaps it was a statement of one of the famous parliamentary that our constitution is a federalism in nature, but spirit is a unitary. But now you have just done a reverse, and by giving the proper example, whether it's a COVID time, whether it's a GST time, whether it's a other situation. Now then I was wondering while hearing you, how can this wonderful argument can come? It's come only when a mechanical engineer drives a car. Then he knows about that, what is the theory, what is the practice. You are being the lawmaker as well as the interpreter of law. So therefore this cocktail has made this decent argument. We are really delighted on this.
As the time progresses, his mind is going to cocktails.
Now, sir, there are several features you have stated to us, and which are really fantastic, and on this analytical approach regarding the Supreme Court approach, that you have given the very perfect examples, that a person is standing in the mid of the road. There is no question that he will be saved. He has to be hurt either way. So therefore, whenever you are thinking to please everyone, there you are bound to commit a mistake. Second, the genius statement which you have given regarding that our parliamentarians were not a fool. They were knowing about everything, but they, by compulsion or by reason, they have committed some mistake, which is very apparent to that. Now this another thing, sir, the conceptual unitary reality which you have said, and regarding the example of the pressure cooker safety valve which you have given in respect of decentralization, that's a local self-government which has come up, and it's a basically which was never thought it when it was made up. They thought it to waiting to the state. Now it becomes a real federal character in a practice. So we are very happy, and we have basically enjoyed this wonderful evening by enriching our knowledge miles to miles ahead from the expectation. Thank you very much. Thank you.
Thank you very much. Yeah, so nice of you. Thank you very much.
Thank you.
Thank you.
लम्बों ने खता की और सदियों ने सजा पाया.